Mr. Sankey.
My Lords, I was just on Article 2.4 of the UN Charter, and just to wrap up on this, the circumstances in which the use of force or the threat of it is permitted are very limited. For example, where there has been authorization by the Security Council under Chapter 7 of the Charter, or an individual or collective self-defence. As Mr. Justice Blair noted, and I'll come back to give you the reference, Russia has never sought to advance any justification to the English court. In terms of where we go next, I was going to take you to the Nicaragua case, if I may, decision of the ICJ, and this is on the topic of Jus Cogens. If we go to authorities, bundle 12, please, tab 113, MS number 4667 is where the decision begins. What did I say? 4867.
Yes.
And if we go to, so that's where the decision begins. If we go to 4872...
I beg your pardon? I beg your pardon?
I'm sorry, my lord. If we go to the beginning of the judgment is 4867.
Yes.
And then I was going to go to 4872.
Thank you.
And just in a nutshell, you see from paragraph 1 at 4872 that the complaint was brought by Nicaragua concerning paramilitary activities, and the complaint was brought against the United States of America. And the ICJ decision in Nicaragua is something of a seminal case. We've seen it referred to with approval in a large number of English appellate cases, including, as we saw earlier this morning, Kuwait and the Margaret Jones case. If we could go, I think we looked at the subject matter. If we go to paragraph 188, which is MS number 4955. And at paragraph 188, you see that the court says that it finds that both parties take the view that the principles as to the use of force incorporated in the UN Charter correspond in essentials to those found in customary international law. The parties thus both take the view that the fundamental principle in this area is expressed in terms employed in Article 2, paragraph 4 of the United Nations Charter. They therefore accept a treaty law obligation to refrain in their international relations from the threat or the use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purpose of the United Nations.
Are you wanting us to read on much further into this?
Yes, I was going to read to the end of the paragraph.
Oh, well, if you give us a moment, then we can do that.
Yes. The court...
Well, we can read it ourselves.
I'm much obliged.
Yes.
So one sees from that paragraph that the principle in Article 2.4 of the UN Charter has attracted the label of Jus Cogens independently of the treaty law obligation of the Charter itself. And you can see some of the supporting material, just to summarise, one sees at 189, second half of the paragraph, reference to the Helsinki Final Act, whereby the participating states undertook to refrain in their mutual relations as well as in their international relations in general from the threat or the use of force. And then at paragraph 190 at the bottom of that page, Nicaragua, in its memorial on the merits submitted in the present case, states that the principle prohibiting the use of force embodied in Article 2, Paragraph 4 of the Charter of United Nations come to be recognised as jus cogens. The United States, in its counter-memorial, found it material to quote the views of scholars that this principle is a universal norm, universal international law, universally recognised principle, etc., the principle of jus cogens. And then, if we could go, please, to MS number 4963. This is a wider principle of jus cogens. Paragraph 205, 4963. And perhaps the court would be kind enough to read paragraph 205 there
Yes.
over the page. And then
Yes, thank you.
I'm obliged. So one sees that the principle there enunciated forbids all states or groups of states to intervene directly or indirectly in internal or external affairs of other states. A prohibited intervention is one bearing on matters in which each state is permitted by the principle of state sovereignty to decide freely. One of these is the choice of political, economic, social and cultural system and the formulation of foreign policy. Intervention is wrongful, uses methods of coercion in regard to such choices, which must remain free ones. So while the force or the threat of the use of force is the paradigm, any action that is aimed at coercing Ukraine's free choice of political, economic, social and cultural system and the formulation of its foreign policy would be caught. The threats are not severable so as to disregard what we describe as economic warfare waged by Russia through punitive trade restrictions. Both the threat of aggression and the threat of trade measures were, and this is our pleaded case, and what the contemporary evidence, including the prospectus itself, suggests, part of the same campaign of illegitimate pressure with the single aim of coercing Ukraine not to accede to the EU association agreement and to accept a deal on Russia's onerous terms. So the ICJ's decision in our submission supports our contention that all aspects of the pleaded Russian actions were at least arguably in breach of clearly established rules of customary international law. And against this background, the Court of Appeal was right, at paragraph 167, to say that the trial judge in any trial of this action should look at all the aspects of Russia's conduct to view the totality of Russian threats and aggression. Now, the second document I wanted to go to after Article 2.4 is the Budapest Memorandum, which you will find in Authorities Volume 19. Authorities 19, tab 179, MS number 7450. And you see there a document dated the 19th of December 1994 under the auspices of the United Nations General Assembly Security Council. And you can see from the underlined heading a third of the way down that parties include United Kingdom, the USA, Ukraine, and Russia. And you see that the text of the Memorandum on Security Assurances in connection with Ukraine's accession to the Treaty on the Non-Proliferation of Nuclear Weapons, signed on 5th December 1994, by the Presidents of Ukraine, Russian Federation, United States of America, and the Prime Minister of the United Kingdom. The context of the memorandum, we say reflecting common standards, was the quid pro quo for Ukraine agreeing to give up nuclear weapons situated on its soil. And the key parts, if we go to 7451, the parties to the memorandum confirm the following. One, the Russian Federation and the other countries reaffirm their commitment to Ukraine in accordance with the principles that the final act, that's the Helsinki Final Act, of the Conference on Security and Cooperation in Europe, to respect the independence and sovereignty and the existing borders of Ukraine. Two, the Russian Federation, etc., reaffirm their obligation to refrain from the threat or use of force against the territorial integrity or political independence of Ukraine, that none of their weapons will ever be used against Ukraine except in self-defense or otherwise in accordance with the UN Charter. And three, the Russian Federation, etc., reaffirm their commitment to Ukraine in accordance with the principles of the Final Act of Helsinki to refrain from economic coercion designed to subordinate to their own interest the exercise by Ukraine of the rights inherent in its sovereignty and thus to secure advantages of any kind. And then if we go on to the Friendship Treaty, and I'll wrap up on the relevance of these in a moment, but if we go on to the Friendship Treaty in the same bundle, look behind tab 189, MS 7620, and you see there a treaty of the 31st of May 1997 between the Russian Federation and Ukraine. And if we go to the next page, 7621, the middle of the page under the recitals, you see the reference to reaffirming their commitment to the norms of international law, above all to the goals and principles of the United Nations Charter, and honouring the obligations assumed within the framework of the Organisation for Security and Cooperation. And then Article 2, in accordance with the provisions of the UN Charter and the obligations of the Final Act, the Helsinki Conference, the high contracting parties shall honour each other's territorial integrity, shall acknowledge the inviolability of the borders existing between them. That's Article 2. Article 3, the high contracting parties shall structure their relations with each other on the principles of mutual respect, sovereign equality, territorial integrity, inviolability of borders, peaceful settlement of disputes, non-use of force or the threat of force, including economic or other means of pressure, the right of peoples to freely choose their own destiny, non-intervention in internal affairs, observance of human rights, etc., cooperation between states and good faith performance of international obligations undertaken, as well as other universally recognised norms of international law. So we submit that the Budapest Memorandum and the Friendship Treaty are very useful in applying the test for duress as a matter of English law. We don't rely on them as the source of directly applicable domestic law rights, directly or indirectly. But the memorandum and the treaty do provide assistance to the English court in evaluating whether Russian threats can be regarded as legitimate for the purposes of applying the English law of duress. And in this important respect, the memorandum and the treaty demonstrate that there is nothing exorbitant or incongruous in applying standards of conduct encapsulated in the English law of duress, which is essentially focused on coercion vitiating consent, to an English law contract effectively between these two states.
I'm still slightly mystified as what we gain from the Nicaragua case, obviously very well known in international law, and the things that were done there were clearly unlawful by that standard. But how does that help us in deciding whether they have any relevance to the English law of duress?
It goes to my fundamental point that public international law is capable of colouring English public policy in this regard.
Well, I mean, what does that mean? I can see that the things indeed it's not in dispute, really, that the things you're alleging in your defence are things which sound in international law, certainly, and international relations. But and just referring us to more and more authorities on that in international law doesn't really get you over the hurdle.
Well, as Q8 shows, English law will have regard to international public policy in determining the bounds of English public policy. And that really is the nub of my submission as to the relevance of this material.
Yeah, I mean, but that's your problem. I mean, it may be, whether you've got there or you haven't got there, the more stuff you put in on the international law side doesn't really strengthen its relevance to English law. It just...
Well, except that English law does take its colour.
Yeah, I mean, we know that, yes.
International law.
We understand that. The only question is, how does it take account of it, and how relevant is that to illegitimacy in the law of defence, law of duress? And
yes,
none of these cases help you on that.
Well, the point I've just made was that there is nothing exorbitant about applying English standards of non-coercive behaviour inducing a contract. When one looks at the material, one looks at Q8, one looks at Nicaragua, one looks at the Budapest Memorandum, one looks at the Friendship Treaty. There's nothing exorbitant about applying English standards, English law standards of non-coercive behaviour inducing contracts to the relationships between states, and these two particular states in particular. Now, you may think I don't need to say any more on the subject in the sense I'm flogging a dead horse because I've made the point.
Well, no, I mean, it seems to me that the crux of this case is we've been going through these authorities for a day and a half now, but the crucial issue is, of course, how any of these authorities inform the law of duress for English law purposes. And unfortunately, we don't have much authority on that other than what Lord Staines's words, and none of these cases actually help us at all on that.
I appreciate that we are in fairly unusual territory on the facts of this case.
Yes, but it doesn't become any more usual by referring us to Nicaragua and the Contras.
No, but the fact it's unusual means that one has to look to various sources of assistance, and in our submission, international law does provide useful assistance in guiding English law, and in particular English public policy. But I don't have very much more to say on this topic.
As I understand your position, what you're saying is that in English law, the proper law of the contract, an apparent consent induced by coercion gives rise to the defence of duress. And when you're dealing with a contract between two states, it is useful in formulating our public policy to have regard to what their commitments are in order to avoid such coercion on the international plane.
Precisely, my lord. And Nicaragua goes further, and the UN Charter goes further in recognising those principles as jus cogens. Now, one of the points made by the trustee is that the only means of taking the various principles I've been referring to into consideration is by using the dispute resolution provisions of, for example, the UN Charter or the Budapest Memorandum. But in our submission, this doesn't really provide a useful answer because Russia has chosen to bring this claim seeking to enforce a contract before the courts of England and Wales, the point the Court of Appeal emphasised at paragraph 175 of its judgment. The only forum where we can raise a defence to the contractual claim is the English court, because that's where the contract is sought to be enforced. And you'll have seen from the Court of Appeal judgment that Ukraine did offer to submit to ICJ jurisdiction in relation to some of the international law issues raised, but no response came from Russia. And the Court of Appeal records that in its judgment. Now, I just want to say a few brief words about non-justiciability and the proper approach to suitability. This has been covered at length now. As the Court is aware, the leading authority is Belhaj. 7 members of the Supreme Court rejected the Foreign Act of State plea by Her Majesty's government. Lord Newburger's judgment is the one that commanded the majority in the Supreme Court. And to save the court time, this court time, the Court of Appeal below cited all the key passages from the majority judgment at paragraphs 169 to 172, at a point in time when the suitability issue was still contested by the trustee. Now, in the light of the trustee's concession on suitability at paragraph 85 of their written case, we don't need to spend more time on Belhaj, but the Court of Appeal judgment is a good, convenient place to find the relevant points made by the majority. But just for your Lordship's note, my Lord Carnworth asked about the judgments of Lord Mance and Lord Sumption yesterday. They both essentially disagreed with aspects of the majority judgment, particularly, for example, Jus Cogens and its relevance, while also disagreeing with each other at key places. To give you some examples, paragraphs 107 in Lord Mance, paragraphs 249 and following in Lord Sumption, but essentially on matters which were obiter because they both concurred in the result. It's not necessarily disproportionate to focus on disagreements between them in the judgments, but in essence, Lord Mance had a narrow view of the Foreign Act of State doctrine and a commensurately narrow view of the need for exceptions. Lord Sumption had a more expansive view of the scope of Foreign Act of State and a commensurately wider view of the scope for applying exceptions. But otherwise, I don't think we need to spend more time on Belhaj. Now, in terms of the public policy exception to the rule, the Court of Appeal's 6 points at paragraphs 175 to paragraph 180, in our respectful submission, are all sound ones and have not been responded to by the trustees in the trustee's written case. But if suitability is truly relevant to the question of domestic foothold or relevance in the way the trustee alleges, those points made by the Court of Appeal do require consideration. Individually and collectively, the Court of Appeal's 6 points are powerful points based on themes of, first of all, Russia's choice of an English law contract and the jurisdiction of the English courts, and disputes known to be determined by a wholly independent judiciary applying the common law, whose development has not ceased, and where we say English public policy, drawing on international public policy as necessary, plays a key role. We say Russia contracted and litigated with its eyes wide open that the principles of English contract law would be applied to the relationship created by the transaction, and that necessarily includes the defences to a claim in contract, including duress. The Court of Appeal made the point that comity points to the English courts resolving a dispute between two friendly foreign states on its merits, but both have voluntarily submitted to the English court, presumably because of their and the international financial markets respect the quality of the system of law applied by the English courts. The claim under the contract and the defence of duress are inextricably linked. The defence calls into question the very existence of the contract under which the claim is brought. And the Court of Appeal makes the point at paragraph 179, we don't need to turn it up, that Her Majesty's government is aware of these proceedings and has not sought to comment on them or to otherwise intervene. And I took the court earlier to paragraph 180 of the Court of Appeal judgment, where they make the point that no one should be able to take advantage in our courts of their own breach of fundamental principles of public international law. And I took you to that passage earlier today. Now, what I wanted to do is just spend a little bit of time on Mr. Justice Blair's judgment and what he had to say about the duress claim. And I know my Lord Conworth was seeking some assistance in where Mr. Justice Blair refers to particular points, and if I can just do that. For volume 2, start at page 95, which is the judgment starts at page 95. We can go, please, to page 138, which is MS 8746. And he deals with Ukraine's defense in a number of places, but I'll take you to the references, if I may. You see at section 2, paragraph 181 through to 185, he addresses Ukraine's defense in summary. We don't need to dwell on that for the moment. He goes into more detail if we go to page 139, MS 8747, Ukraine's pleaded defence in respect to the avoidance of the Eurobond transactions at letter G. And he says the factual aspects of Ukraine's pleaded defence as to duress in respect of avoidance of the Eurobond transaction in response to the trustee's case on affirmation are both set out in full in the annex and are summarised here. Just for your lordship's note, I don't propose to go to the annex, but that begins at page 177, MS 8785. And this section goes through to paragraph 209 on page 143, page 8751 MS. If you just focus for a moment on paragraph 202 at 8749. There's a useful summary of some of the key threats which were made by Russia in the run-up to the Vilnius summit, at paragraph 202. If the court could just glance at those, and threats to territorial integrity are dealt with at Little Roman 7 and 8 and 9. And then if we go to paragraph 203 over the page, see it said that each of these actions was illegitimate and or unlawful in that Russia's public statements in offering to support the partition of Ukraine were a threat of the use of force directly or indirectly, contrary to customary international law, which for all has the status of jus cogens and or Article 2.4 of the UN Charter, and b, a breach of Russia's duty under customary international law to refrain from intervention in the internal affairs of a sovereign state, namely Ukraine, which duty has the status of jus cogens. And then can I ask the court please to pause at paragraph 216. And you'll see that Mr. Justice Blair quotes from the prospectus and so this is in the prospectus for the issue of the Eurobonds in issue in this case. It says, recently pressure was placed on Russia-Ukraine bilateral relations arising out of the prospect of Ukraine signing the association agreement with the EU, including the threat of restrictive trade measures by Russia. For the 9 months ended 30 September 2013, exports of Ukrainian goods to Russia decreased by 13.4% as compared to the corresponding period in 2012. As at the date of this prospectus, discussions are ongoing between Russia and Ukraine in relation to restoring industrial cooperation and trade and economic relations between the two countries, following the decision of Ukraine to defer signing of the association agreement with the EU. The work on the preparation of a roadmap for continuing negotiations between Ukraine and the EU remains in progress. If for any reason the announced economic and financial support is not forthcoming from Russia and Ukraine in the future signs the association agreement with the EU, this could impact trade and other aspects of Ukraine's bilateral relations with Russia and could lead to the imposition of trade and other punitive measures by Russia. These factors in turn could have a material adverse effect on the Ukrainian economy. So one sees that there was no secret about the punitive nature of the Russian measures towards Ukraine and their purpose in the prospectus itself for the issue.
I think it's fair to say the sort of emphasis at that stage was that although Ukraine was entering into the agreement, it might be forced to default because it wouldn't be able to do anything. And it was only 2 or 3 years later that the idea of a duress defence came to light as a result of advice, no doubt, of English counsel. But so they weren't at that stage saying the whole thing's invalid because of duress. They were just saying, well, if we enter into it, you've got to realise we may well default.
I'm simply dealing with the evidential basis for the claim.
Clearly, it was very much on the table that there were these threats going on.
Yes, absolutely. And there is more detail from the prospectus in the annex, which I'm not going to spend time on, but just for your Lordship's note, it's of this bundle, its pages 186 to 7, MS 8794. And then if we could go back, please, if we go on to paragraph 221, if the court could glance at 221, 222, it's a helpful summary by the judge as to what led into the Eurobond transaction. 221 and 222. And if the court is up to there, could I go please to paragraph 249 at page 148 MS 8756?
I wonder, just before we look at 249, I see it's just as a matter of understanding how things developed. It's interesting to see 236, which sets out Ukraine's arguments before the judge, and it's rather similar to where we, I think, got to this morning.
Yes.
We can see what's said in the last few sentences of 236.
Yes, indeed. And then 249. These are important paragraphs. If one looks at paragraph 249 at MS 8756, Mr. Justice Blair says, at 249, Ukraine's factual case as to duress is set out at length in the evidence. Russia's case is not set out. And then at 250, perhaps the court could read, and then 251, Ukraine cites ample material supporting its factual case that Russia exerted strong pressure on Ukraine with a view to preventing it entering into an association agreement with the EU, e.g. a European Parliament resolution on the 12th of September 2013 deploring Russian pressure on Ukraine in the run-up to the Vilnius summit, as well as contemporary press commentary. Now, the European Parliament resolution, if I can just give you a reference to it, because it's important because it shows the contemporary understanding of the purpose of Russian pressure was pretty clear. And it's MS 10179. Is it Appendix Part 2, Volume 4, Tab 50, page 1571. And then at 252, the judge says, in one respect there was a dispute on the evidence. Mr. Mason Jebb, the trustee, sought to challenge Ukraine's case that the transaction contained terms that were onerous and unusual, specifically the GDP ratio clause and the cross-default clause, and the 2-year term of the bonds. The detail of those clauses, we don't need to dwell on them, the detail of what those clauses entailed are set out for your Lordship's note at paragraph 218 of the judgment of Mr. Justice Blair. And then one sees in the same paragraph at the top of the next page, 3 lines down, the court proceeds. It says, however, there is an issue to be tried in this respect which cannot be resolved on a summary judgment application. The court proceeds on the basis that the terms of the Eurobonds were onerous and for Ukraine unusual. And then at 253, you see the judge deals with continuing duress, deals with this is following the invasion of the Crimea, European Council regulations, the General Assembly of the United Nations, and then a reference to the United Kingdom Foreign Secretary, at that stage it was Mr. Hammond at Little Roman 4, condemning the illegal annexation of Crimea. And then if we could please go on to page 272, paragraph 272, page 152, MS 8760. This is the paragraph where Mr. Justice Blair makes the point that not credible to describe the claim as an ordinary debt claim. So that's not to say that lending by one state to another does not sometimes or even usually come with strings attached, but as it's put in Ukraine's defence, Russia's policy can be seen as keeping it on a tight leash, and that assertion is sufficient on a summary judgment application. And then if we go to paragraph 295 at page 155, I think this is the reference I did not give my Lord Colmworth this morning, but at paragraph 295, MS 8763, Mr. Justice Blair says the Court's conclusions as follows. 1. Ukraine has made out a strong case that economic pressure applied by Russia by way of trade measures during 2013, along with threats, led to its government's decision not to sign the EU Association Agreement at the Vilnius Summit on the 28th of November 2013 and to accept Russian economic support instead. And then at Little Roman 2, Ukraine has also made out a strong case necessary to see this as more than simply economic. Drawing closer to the EU is a fundamental national policy objective since the breakup of the USSR in December 1991. Both the nature of the pressure and its effects were therefore of profound consequence to the state. Now, can I just make this point, pausing there, that the threats were taken very seriously at the time by Ukraine, and rightly so.
I mean, there's no dispute as that. I mean,
No.
what's striking is that Mr. Justice Blair found the facts pretty strongly in your favour. You're not going to lose on the facts. The only question is that he then decided that they were not justiciable,
Yes.
which is all we've been arguing about for the last day and a half. So one doesn't really get any further by sort of
Well, the point I was about
the same point.
The point I was about to come on to is that there has been a thin attempt before this court in the written case by the trustee. Obviously it can't and doesn't challenge causation, but there's been a thin attempt before this court, as there was before the Court of Appeal, to diminish the significance of Russian threats of aggression.
But if it was very thin.
Well, but
I mean, he may be right, but I mean, it seems to me the facts as found here are pretty striking.
yes, well, if
I
your
may be
lordship,
wrong, but I didn't get the impression that they were.
indeed, if your lordship will allow me, I
Yes,
just want to refer then
Let me
finally.
just make it clear. I mean, we haven't, for the purposes of a summary judgment application, disputed the facts, because our position is, as a matter of law, they don't amount to a row of beans.
Yeah, well,
We said in making that, the court has to treat those facts as the facts. If we're wrong on our point of law, then all the facts will be in issue in due course.
Yes.
We simply haven't gone on the record as to what our position is on the facts, which is what one would expect on any effectively strikeout type application.
If I can just complete this, paragraph 308, at page 158, MS 8766. So 308, Little Roman 1. The trustee tended to diminish the significance of these threats in oral argument. However, as Ukraine rightly says, the threat of the use of force in 2013 has to be seen against the actual use of force in 2014. Further, it says that the lack of evidence of direct government-to-government threats has to be seen against the fact that the senior members of the Ukrainian government fled to Russia in 2014. The court sees no reason not to accept these points. In English law, violence to a person or threats of such violence have long been recognised as a paradigm form of duress, entitling the victim to avoid a contract entered into as a result. If the same approach is applied to Ukraine's defence, its case is plainly a strong one, particularly on a summary judgment application. And at 4, this is the paragraph I referred to earlier, the first question is whether there is a sufficient factual foundation for a decision as to justiciability on the summary judgment application. It refers to Lord Sumption's judgment in Belhard, which we looked at paragraph 267. There is such a foundation because Ukraine's case as to the threats made is credible and has not been answered. And then just at 7 on the same page, you see that the judge says at some weight that there is no UNSC resolution, albeit it was the exercise of the veto by Russia that prevented the adoption of the resolution, declaring Russia's actions unlawful the other members of the UNSC voting in favour, apart from China, which abstained. So Ukraine's assessment of whether the threats were serious turned out to be correct. And in our submission, it may be useful just to contextualise this, to look at what the evidence of Minister Danyuluk stated, which is in Appendix Part 2, Volume 1. And if we go, please, to page 513 of the bundle, MS 9121, you see this is a statement by Mr. Danyuluk, who at the time of making the statement was the Minister of Finance of Ukraine. And then paragraph 7 at page 9123. And could I invite the court to read paragraph 7 through to the end of paragraph 9, please? Obliged. I was going to then turn, if I may, to the issue of stay. In our submission, the Court of Appeal was right for the reasons it gave at paragraphs 183 to 186 of its judgment, that if the matter was not justiciable, then the only proper approach would be to stay proceedings. Any other approach would be entirely unfair and would place both Ukraine and the court in an impossible position. It's unclear whether the trustee seriously disputes the point. Trustee's written case, paragraph 187. We say that if the Foreign Act of State doctrine is engaged and the matter is not suitable for determination by the English court, the proper outcome and fair outcome is a stay. Now, there doesn't appear to be a substantive challenge to this in the trustee's written case. It appears to be more or less accepted that once there is a domestic foothold, the outcome is either a trial or, if no trial, a stay, and you have our submissions on why there is a domestic foothold.
If I can make it clear, our position is that if there is a domestic foothold, your Lordship understand we say there isn't, except there should be a trial. So we're not seeking a stay, and as I understand it, Ukraine says if they have a domestic foothold and there should be a trial. So as I see it, the question of stay doesn't arise unless the court itself took the view.
Yes, and the reason I deal with it is because it's not possible to waive non-justiciability. It's one thing for Russia to waive non-justiciability. Ultimately, it's a question for this court as to whether it regards the matter as suitable and justiciable. It's not possible for one party simply to waive any non-just. Ultimately, it's a matter for the court whether it regards the matter as suitable for judicial determination by the English courts or not. So I can't ignore the question of stay completely because it may arise depending on the court's conclusions. And a stay was the principled outcome in Butte's gas. And it reflected that the court could not decide any of the claims without, in reality, taking a side where one party would effectively have his arm tied behind his back. Well, it would be grossly unfair to allow the libel claim to proceed, but not to allow the defence of justification to be run, because it was non-justiciable in the terms analysed in Butte's. And I should emphasise...
Your case essentially is very, very similar to Butte's.
Yes.
Yes, it's the same fundamental reasoning.
Exactly.
Yes.
Very difficult to see what the distinction is. I mean, the trustee has attempted to say there's some sort of special category for defamation cases, but it's very difficult to find any sensible distinction from our case.
They're not, as I understand it, seeking to distinguish.
They did. They do in their written case, and they did orally. So, and we submit that they are wrong for the reasons my Lord Hodge states. Very difficult to see what a relevant distinction would be between our case and Butte's. And I should emphasise that we did not propose, and are not proposing, a permanent stay to facilitate resolution of any international law disputes. As you will have seen from the Court of Appeal judgment, Ukraine undertook to consent to ICJ jurisdiction, and that offer has been repeated in our written case at MS 8547, and has never been answered by Russia. See Court of Appeal, paragraph 185. And in relation to the approach in Butte's and the cases on stay, the only case where different principles have been applied was by Mr. Justice Blair, a first instance in this case, where he declined to order a stay. And the relevant paragraphs, without turning them up, where he dealt with this matter at paragraphs 312 and 377, subparagraph 5 of his judgment. That conclusion was overturned by the Court of Appeal, and the Court of Appeal's approach to stay is strongly supported by authority. We have seen Butte's gas. I can give you one more reference, which is to Lord Mance, paragraph 42 in Belhage, without turning it up. We have seen Shergill, paragraph 42, citing Hamilton and Al-Fayed. Perhaps I should just show you a case you haven't seen, which is Al-Rawi at Authorities Bundle 4. And I'm really looking at this for endorsement of a decision of the Court of Appeal in Carnduff, so I don't need the head note for present purposes.
Which page?
So if we could go please to MS 1523 in the decision of the Supreme Court in Al-Rawi. Pick it up, the bottom of page 1523 in the judgment of Lord Mance. And just below letter H in paragraph 108, Lord Mance says, as I understand it, no member of the Supreme Court doubts the approach in Carnduff and Rock. And he refers to the other judgments in Al-Rawi. And he says, in other words, a successful claim for PII can make an issue untriable so that the court will simply refuse to adjudicate upon the case. In some circumstances, therefore, the court is faced not with a binary choice between trial with or without the material for which PII has been claimed, but with a trinary choice. The third possibility is no trial at all. Whoever happens to be the claimant then has no access to the court. And then if we go to Lord Clark, at paragraph 157, MS 1538, paragraph 157, Lord Clark refers to submissions by Miss Rose, and 4 lines from the bottom of the page. He says, it was in this connection that the court was referred to Carnduff. In that case, a registered police informer brought an action against the police inspector and his chief constable to recover payment for information and assistance provided to the police. The Court of Appeal struck out the action on the basis of the fair trial of the issues arising from the pleadings would require the police to disclose sensitive information, which it would be contrary to the public interest to force the police to disclose. Lord Justice Laws said at paragraph 36 that a case which can only be justly tried if one side holds up its hands cannot in truth be justly tried at all. Perhaps noteworthy that the claimant complained to the European Court of Human Rights in Strasbourg on the basis that his right of access to the court under Article 6 of the Convention had been infringed. His complaint was rejected as unfounded. I don't know whether it's maintained, but the trustee in its written case proposed a partial stay only of the international law issues, not the whole claim. It's a trustee's written case, paragraph 188. And they suggest that they could, for example, have a trial of the issue of causation alone. Now, in our submission, without making full findings of fact as to the nature, extent and scope of any duress, it's impossible to decide the question of causation in isolation. To give such a direction would be the worst and most dangerous kind of preliminary issue. likely to lead in effect to a full trial, inevitably involving consideration of the foreign actor state area in practice, and not likely to be a useful shortcut. Causation and the extent of the pressure and the nature of the pressure are closely intertwined, and one cannot possibly decide one without the other. And if I can just show you the Power-On case at Authorities Bundle 13. And the case begins behind tab 117 at MS 5129. And I just need to show, if I may, page MS 5150. And page 635 of the report, under the heading the third question, Lord Scarman says that duress, whatever form it takes, is a coercion of the will so as to vitiate consent. And perhaps we can pick it up just above letter D. In determining whether there was a coercion of the will such that there was no true consent, it's material to inquire whether the person alleged to have been coerced did or did not protest, whether at the time he was allegedly coerced into making the contract, he did or did not have an alternative course open to him, such as an adequate legal remedy, whether he was independently advised, and whether after entering the contract he took steps to avoid it. All these matters are, as was recognised in Maskell and Horner, relevant in determining whether he acted voluntarily or not. So one can see that causation and the extent and the nature of the pressure are closely linked, and one cannot sensibly decide matters such as causation without considering the underlying cause of action and the defence.
I think the way, my impression is the way that Lord Scarman discusses the law in this judgment on pages 5150 and 5151 may have been overtaken by later authorities.
Well, it's certainly in terms of some of the labels used about coercion of the will and so on. But
and frankly, this is a law I remember learning as an undergraduate, and it's
Yes.
It seems quite simple and straightforward to apply. But the more modern case law is good to be more complex.
But it's very, very fact sensitive is the ultimate point. I mean, I could show you other examples like DNSD sub C, where there's a whole range of factors which are prayed in aid in determining whether there is true consent or whether consent is vitiated, such as, for example, whether the demand was made in good faith or bad faith, that type of very highly fact-sensitive issue. And I showed you Power-On just as a good example of how causation and whether there is duress at all is closely linked, but I could show you other examples where the law has developed, as it were. But in terms of the close link between the underlying question of duress and causation, it's a good place to start. Now, the Court of Appeal referred at paragraph 179 to the fact that Her Majesty's Government is aware of these proceedings and has not sought to comment on them or to intervene. And they also pointed to the fact that various statements had been made by the executive in relation to the position in Crimea. I don't want to take time going through those references, but in terms of the EU Council, can I just give some references to the court?
What's this for? Why?
It supports, just giving some colour to what the Court of Appeal says at paragraph 179 of its judgment. Just because it didn't cite specific examples, I thought it might be of assistance to the court.
Thank you.
Some examples. So in terms of statements by the executive, I won't trawl through all the possible examples you can have, but the statement by the Foreign Secretary at Appendix Part 2, Volume 5, page 1987, MS 10599. And it's interesting that because the Foreign Secretary makes reference not just to the UN Charter, but also to the Budapest Memorandum and the Friendship Treaty. Similar statements by the UK representative to the United Nations Security Council, Ambassador Rycroft. And if I may just give you one reference, Appendix Part 2, Volume 5, page 1945, MS 10557. Then the EU Council, this is in the Authorities Bundle, Authorities Volume 21, tabs 214 and 215. The MS numbers are 8084 and 8086. And then you'll see the Court of Appeal makes reference to the European Union sanctions regime, which is directly in the United Kingdom. And the references for that are Authorities Volume 21, tabs 217 to tab 220, beginning at MS 8118, and Authorities Volume 21, tabs 223 to 225 for the UK statutory instruments, beginning at MS 8153. And if I may just add a couple of references, first of all, to a statement by the Prime Minister of the United Kingdom, which I referred to when I opened, which is Appendix Part 2, Volume 5, page 1975, MS 10587. And then the UN General Assembly, Authorities Volume 21, tabs 226 and 227, MS numbers 8206 and 8235. And finally, the Council of Europe, Authorities Volume 21, tab 222, MS 8150. Lords, unless I can assist you further, I've actually finished slightly ahead of schedule.
That's not a problem as far as we're concerned. It's hard. Oh, yes. Yes, I should have asked Mr. Jaffe. Do you follow? Very well, Mr. Howard.
My Lords, can I say firstly at the outset of my reply that it is important that we do not lose sight of the question that is before the court. The issue boils down to this. It is whether the pleaded defence in fact discloses a defence as a matter of English law. That's the question. And properly analysed, it does not. So, and in my submission, this case involves proper application of legal principles to the facts which Ukraine has alleged. Now, there's nothing novel about that. Now, first, the case is put forward as one of duress, entitling Ukraine to vitiate the contract. So, as I think my Lord Reid said, these are my words, not yours, but it's important first to be clear about the content, the contour of the law of duress as a matter of English law. Now, it is concerned with what have been called illegitimate threats. Now, the paradigm case is a threat to do something which is unlawful. And that's unlawful as a matter of English law. And it's not disputed by Mr. Thankey in his submissions that that is where one's looking at unlawfulness, it's as a matter of English law, nor does he dispute that where you're looking at conduct which is not unlawful, but which is otherwise categorized as illegitimate, that is by reference to English standards. Now, before considering that, and I made the submission to you yesterday, that otherwise illegitimate is looking at things which might not be strictly unlawful, but which the law, English law, otherwise condemns. But what is important, though, to consider, because in the light of some of the exchanges between the court and Mr. Thankey, is this. The law of duress, including the law of economic duress, is not concerned with a situation where somebody simply takes advantage by exercising pressure on somebody else. So, I mean, the obvious example is if I'm the supplier of goods, which you, I realise, desperately need, one might think, well, it's sharp practice that I hike my prices by tenfold because you're in desperate straits. But that is not duress as a matter of law. There may be other areas of the law, abuse of dominant position and things like that, abuse of markets, where the law can step in. But assuming we're not in that category, I am entitled to do that. So it's not simply behaviour which somebody might, exercising palm tree justice, say, well, I don't think that's a very nice way to behave, or anything like that. So that when you look at the CTN cash and carry case, and I would commend going back to that, and you see what Professor Birks was saying, what he was recognising is that there can be times when somebody is doing something which is strictly lawful, but nevertheless it's the type of thing which still can be condemned. Now, it is important to note there is not a single reported case which concerns the moral or social type of behaviour. The nearest one comes to it is the decision of Mr. Justice Cook, which when you actually look at that was a case where there had been repudiation of a contract, a promise to do to compensate, and then a supply of an alternative vessel. And what the wrongdoer sought to say, well, I'll only now supply the alternative vessel if you, the charterer, agree to waive all the prior claims arising out of my repudiatory breach. Now, it's quite easy to see in that context why Mr. Justice Cook and the arbitrators said, well, it may not be strictly the demand at that stage unlawful, although actually it probably was, but where it arises out of your prior unlawful conduct, an attempt to take advantage of that, that's the sort of thing the court will not allow. But what we are concerned with here is whether the alleged threats in this case, and I stress the word alleged, whether they are capable of being threats which are unlawful or otherwise illegitimate as a matter of English law. Now, the next point that has become very clear, where there is a sharp divide between the parties, and in my submission, Mr. Thankey's submissions are entirely wrong on this, and that is what is meant by a domestic foothold. And Mr. Thankey's submissions have exactly the same confusion and circularity as one found in the Court of Appeal's judgment at paragraph 159. Mr. Thankey and the Court of Appeal say, and this is what it comes down to, they say if you have an English cause of action or an English defence which raises an issue of unlawfulness, the mere fact that you are either able to assert the claim or assert the defence provides a domestic foothold for considering unlawfulness as a matter of international law. So, for instance, here there is a defence, but let's assume the claim was for intimidation as a tort, so an ingredient of which is unlawful means, a threat by unlawful means, or a conspiracy by unlawful means. So if you simply make that allegation, or the Butte's gas case, you remember, there was a conspiracy by unlawful means alleged. Now, on Mr. Thankey and the Court of Appeal's argument, the fact that you are alleging conspiracy by unlawful means is sufficient to allow you to say the unlawful means is the breach of international law. That, in other words, simply the fact that I am asserting an English cause of action is my domestic foothold. In my submission, that is a complete misunderstanding of what the cases mean by domestic foothold. What the cases mean is that you have a domestic foothold for to raise the allegation which allows raising the an international law issue. Now, it all depends on the nature of the issue. Butte's gas, Mr. Thankey says, is a roadblock for me, and he holds that as a flag, saying this is the case that shows he's right on this point. Butte's gas doesn't show anything of the sort, and it is very important to just bear in mind what Butte's gas, the simple point. It's not that there is a special law relating to libel, it's you have to look at the cause of action in the particular case, or there the defence. The cause of action was libel, so what was being said by the claimant was, you, defendant, libelled me, defamed me, by making these statements. The defendant wanted to say they were true. Now, the reason a foreign act of state arose is that the facts that were being put forward, which you were entitled to put forward as part of your plea of justification, those facts then went into foreign act of state. But you didn't have any problem of having to incorporate international law into English law. It was simply there was an allegation that this is true, I can justify it, because you were doing these things in breach of international law, of public international law, or whatever it was, the particular dispute there. Now, our case, by way of contrast, or if I go back to my example of a conspiracy to injure by unlawful means case, the unlawful means has to be unlawful as a matter of English law. So you can't pray in aid customary international law or a treaty unless you can show that breach of the customary international law or breach of the treaty is a breach of English law. And that is why you get involved on our case in relation to the unlawful aspect as on a question as to whether the customary international law has been incorporated into English law. Because if it hasn't been incorporated, for instance, if one takes the simple case of a tort claim, I mean, if a Ukrainian brought a tort claim in alleging that there had been a threat by Russia to invade, and that was unlawful, that wouldn't be, it's not simply you don't get to the, justiciable on the suitability question, it's they wouldn't have a claim as a matter of English law because they wouldn't be able to demonstrate that what was threatened was unlawful as a matter of English law. Well, that would be the question. So Butte's gas is not a roadblock. It's simply that on the type of allegation that was made in Butte's gas, they were entitled to plead justification, albeit that as part of that story, you would then be going into international law questions. Similar point arises, in other words, the justification plea isn't a domestic foothold in the sense of what we're talking about. It's simply that that is a plea as a matter of English law that you're entitled to make. And if that involves looking at questions of, on the international plane, that just raises a suitability question. Shergill is similar. The question was, who was in fact the successor, I think, to the Holy Saint, as I understand it. So that required the court to then decide questions of essentially religious matters, which a court wouldn't normally do. But that's because the substantive question was, who is the successor? And so that, rather like a right to property, or I think it ultimately was a right to property, that had to be decided. Now, in our case, everyone appears to recognize that the trade treaties that have been referred to and customary international law are not part of English law. So in our submission, a claim, if we just, and I'll come back to the pleading in a moment, but a claim that there has been a breach of one of these treaties or breach of the customary international law prohibition on the use of force cannot be relied on unless it is incorporated. Now, as to the standard of legitimacy for the purposes of the law of duress, once one understands how that comes into the law of duress, in my submission, what you can't do is then, having rejected, as I suggest you have to, breach of customary international law or breach of the treaties, you can't reintroduce it as a standard of legitimacy. Now, so the first...
I'm wondering why not. Certainly, if the international law doesn't form part of domestic law,
yes,
then I understand you can't characterise the conduct as unlawful.
Yes.
But we know that there is this residual type of duress which is caused by, which is well as pressure, which is not unlawful pressure but illegitimate pressure.
Yes. I mean that's the area we're exploring as to how far that goes.
Yes, and
well,
there are that. I mean, that's where we saw Lord Justice Steyn talking about what was socially acceptable and so forth. Personally, I've found the most useful discussion to be in the Royal Boscalis case and Lord Justice Phillips, where he actually gives an example back in 1903 of.
So could you just tell me which bundle you're in?
Yes, I'm looking at it's in bundle
three.
three.
Yeah, tab 17.
Tab Tab 17, yes. And his discussion of it begins on page 1201, MS 1201.
Yes.
And you'll see he cites the then, just at letter D, he cites the then current edition of Dicey and Morris, who tell us that a contract may also be void were the circumstances in which it was made rendered incompatible with English ideas of justice and morality. And the
Sorry,
example.
I'm just not quite with you.
Oh, I'm sorry.
Page 1209.
1201.
1201. I'm sorry, I beg your pardon.
At letter D,
Yes, sorry.
he's just beginning his discussion of duress with this citation from Dicey and Morris's 12th edition,
Yeah.
where he talks about the circumstances in which a contract was made, rendering it incompatible with English ideas of justice and morality. And then the citation is of Kaufman and Gerson. And over the page, he cites the Master of the Rolls between F and G, saying that if the plaintiff is setting up a contract obtained in a manner which, in the case of an English contract, the law deems contrary to morality, an English court will not help him to enforce it, whatever may be the law of the country in which it was made. And he then goes on, Lord Justice Phillips, at MS 1204, F to H, to conclude that there appear to be two classes of duress. First of all, where the conduct is so shocking that an English court won't enforce the contract regardless of what the proper law of the contract is.
Yes.
An example being Kaufman and Gerson. And then cases like Dimscal Shipping, where under English law as the proper law of a contract, the duress is regarded as unacceptable. Or as he puts it, yes, unacceptable.
Yes.
Now, as I understand Mr. Thankey's case, his argument is that the pressure that we are concerned with in this case is illegitimate in those terms.
Yes.
And the only significance of international law standards, I mean, ultimately, it may not actually matter very much, unless it's lex cogens, I suppose, in which event that would reflect English public policy.
Lord, the reason it does matter is this. And I think Mr. Thankey at one stage in his submissions accepted this. What you're looking at in this case is relationships between two states.
Yes.
You're not dealing with something. They've entered into an English law contract, but the matters that are complained about are all at the interstate level. And the simple point is that relationships between states, there is no morality or other such concept. The standard of behaviour of states is only something which can be judged as a matter of international law. There's not some freestanding point where you're talking about dealings between two states.
Well, can I just press you on that?
Yes.
The case we just looked at the Royal Bascalis.
Yes.
If I remember correctly, is this the Iraqi? This the case about Iraq threatening to use people as human shields?
Yes, but the allegation, quite actually, one should see what actually was being pleaded in that case. Mm-hmm. So this isn't a case where the Foreign Act of State doctrine was in issue. And what was alleged in the case is in the, you can see it's set out in the, at page 1163, is there was a pleading of, at F you can see duress of persons and duress of goods.
Yeah.
So that's what was specifically pleaded.
Yeah.
And so that, and that's what the issue in this case, as I think one saw, was what, and what was actually happening. I mean, you can see it, what was being described as, this was all a ransom demand.
Yes.
And so, and the point was, as a matter of, once you categorized it as ransom, saw that's really what had gone on, then the agreement, the commercial agreement that had been entered into under ransom, was treated as a matter of English law as procured by duress, and it didn't matter what the proper law of the contract was. And the case that you were referring to from 1904.
Yes, where it was French law that was the proper law.
That's right. But the conduct, the important thing is, the conduct in that case was conduct which by English standards was regarded as completely improper. If you remember that the husband had stolen some money and
Yes, it was a threat to effectively report him to the police, and he would then be at risk of prosecution, and the wife succumbed to the pressure.
Exactly. And so, as a matter of French law, that was not regarded as irreprehensible. And the point, I would suggest, the point that comes out of that is, if you come before the English court and you're seeking to enforce a French contract, if the way in which you've procured that French contract is by English standards regarded as unconscionable, the fact that French law wouldn't interfere doesn't matter, because it affects effectively the conscience of our court.
Yes. Yes, obviously the result would have been the same if a contract had been governed by English law.
Yes, but that's all it's doing, is it's slightly extending our principles. Yeah. But in my submission, if one comes back to our case, does this case assist? In my submission,
well, would the result have been different if, instead of the ransom demand and the threat to use these people as human shields, instead of being directed against a commercial enterprise, had been directed against another government?
If the threat, for instance, if what had been said is, well, we entered into this contract, I mean, it would actually come back to the same issue as we're dealing with here, and there was a threat by the Iraqi government to invade Kuwait, say. This was all around the time of the first Kuwait War, contrary to Article 2.4. Would that be something that the English court could take cognizance of? Now, in our submission, no.
That's this case.
That's this case.
But I'm wondering, on the facts of that case, was it critical that the party being subjected to the pressure was a private organisation, a commercial company, rather than Iraq exerting the same pressure by holding, say, British citizens and telling the UK government that they would continue to be held and perhaps be positioned in places where they might be in danger, unless the UK, for example, lifted sanctions?
Well, when one searches for these analogies, one's got to remember one's got to then find an English contract.
Well, that's true.
Because otherwise, it's so that what one's got to look at is, if one follows through your Lordship's line of thinking, let's take first an example where the UK government says to Iraq, if you don't desist from certain behaviour, we are going to invade. But if you do desist, we will lend you some money, so you can rebuild your hospitals or whatever it is. And this contract, rather like here, you do it as a commercial contract and not state-to-state lending. Now, if we take that example, would Iraq be entitled to say, well, the threat by the UK government to invade, and we get back into all the discussion about if it were a Mr. Blair type situation, whether you are complying with UN Security Council's resolution, would the English court entertain that? Would it say it was relevant? In my submission, when you put it in those terms, the English court, I suggest, would say, no, it's not for us to entertain this, but it would say, because the allegation isn't relevant. So, as well as it not being suitable. So you've got to always come back to there being a contract, and you have got to In our case, we're dealing with interstate relations, and you've got to then determine on what plane interstate relations take place.
Yes. Yes, but I mean, what was really in my mind was whether, if you had a case of duress of persons, which is what
Yes,
this case is, but that case
that
was about, would it make a difference if the person being subjected to the duress was a
Yes.
sovereign state
Sorry, I should
rather
have
than a
made it
private
clear.
company?
Where you've got a case of duress of persons, say, by the state, so it goes back to Mr. Banki's example. If you hold a gun against the finance minister's head and say sign or else in this sort of mafia approach, that is a classic case of a threat of duress of person.
Yeah.
And so you have a domestic foothold like you do in Belhage, or domestic foothold doesn't arise, because what you're alleging is you were threatening to do something which is unlawful as a matter of English law. It is unlawful to hold a gun against somebody's head and say sign or else I'll blow your brains out. So that type of case simply gives rise to the suitability question, like in Belhage.
Yes.
But that's why it's very important to distinguish. In our case, that what is being alleged at the interstate level is conduct between the two states. So that these graphic examples, you can say, well, what would have happened if President Putin had done these sort of things? The fact is that isn't what the case is about. It's all about things between the Russian Federation and Ukraine. Now, the first area of central area of dispute is what is meant by domestic foothold. The second area is, which Mr. Thankey disputes, is whether the question of suitability is also relevant to determine the domestic foothold. And Mr. Thankey's submission is that it isn't, that when you're determining domestic foothold, he says you're simply looking at the cause of action. Now, in my submission, Jones, Gentle, and Mohammed Sardar are all cases which make it clear that in determining the scope and existence of a domestic legal right, you consider what the exercise would entail. That is what is said in terms. Now, Mr. Thankey spent some time going through Jones to say that Jones is only about crime and is very limited. That is wrong, both on its own face, but it's also wrong because Lord Mance in KU at paragraph 146 and specifically rejected that point. Now, the suitability question, as I said, I'd invite you to go back to those cases. Obviously, I won't do that now. Is relevant, or comes into determining the relevance question, where the basis upon which somebody is seeking to look at international law is because they are saying international law is either itself part of English common law, or because they're saying international law is in some other respect incorporated, for instance, as a standard for determining how states behave. And I would respectfully suggest that the court needs to be careful that we don't go down a route where we just use semantics to avoid confronting what is happening. So that my submission is it's absolutely clear that one can't say, for instance, that the customary international law prohibition on use of force is part of the common law. And if this court then says, well, we agree with that, but we're going to say, as part of the law of duress, that can be considered in the way either that Lord Sales does at paragraph 160, which is just literally relabeling it, or if one does it by reference to calling it a guide or anything similar with respect, these are just semantics. At the end of the day, the court is doing exactly the same thing, which it is saying, for the purposes of English law and for the purposes of the English law of duress, it is saying we will consider interstate conduct by reference to international law. Now, in my submission, that is, as I said yesterday, entirely contrary to a whole line of authorities and inconsistent with them. Now, as I understand Mr. Thankey's submissions, and I think what he says is that he disputes that the relevance question arises in the way I say, but I think he says, well, if it does, and you have to consider suitability, there are public policy exceptions to suitability which you consider, which would allow you to treat the allegations in this case as relevant. And for that purpose, as I understand it, he therefore relies on the 6 points that the Court of Appeal put forward as the reasons for the public policy exception. Those are the 174 to 180. Now, it's actually very important that one doesn't get muddled at this stage. The Court of Appeal at paragraphs 174 to 180 was dealing with the public policy exception because the Court of Appeal had already decided against us on the relevance question. In our submission, when you deal with the relevance question, what you are deciding is, as a matter of the law of duress, what is the standard? So that if we're right about that, you don't in fact get into the public policy exception. And that's what we said in our written case. But we also answered the points in our written case. Mr. Thankey said we hadn't dealt with it. That's not right. We dealt with it at paragraphs 156 to 162. Now, the next point I just wanted to come back to is this suggestion that Ukraine's case does not rely on or require the court to determine international law. Now, in my submission, that is plainly wrong, and it is plainly wrong for a number of reasons. The first point I want to make, if that point is right, then, of course, the whole approach of the Court of Appeal goes out of the window, because the Court of Appeal's approach at paragraph 160 requires all of the international law questions to be determined in order to determine illegitimacy. And that's the only yardstick on the Court of Appeal's approach. Now, secondly, it is clear when you, and it was noticeable that Mr. Thankey didn't take you to the pleadings and go back to that. Of course, we're now all, I'm sure, familiar with it. But if I can just ask you to have it open again in Core Volume 2. So I've given you the, where is it? Yes, Core Volume 2 at page 8823. There is no question, if one actually goes to Ukraine's pleading, that paragraphs 19.2, 19.3, 21.1 and 21.2 are all expressly pleading breaches of international law. And that's plain as a pikestaff. Now, if international law is irrelevant, as we say it is, or it's not part of English law, then in our submission all of that has to come out. Now, Mr. Justice Blair, you were taken to his judgment today. Could I just remind you of a point that he made at paragraph 286, when he was considering the trade restrictive measures. Paragraphs 286 to 287, where he made the point that what determination of the case would require. Firstly, the trustee says correctly it would require the court to interpret the treaty's agreements, determine whether the imputed conduct occurred, determine if it constituted a threat, and whether it was of conduct that was in breach of the treaties. Further, to decide whether the trade restrictions were spurious or bona fide or were for an ulterior purpose would require a determination of motive in the sense of whether Russia's basis for imposing trade restrictions was legitimate and consistent with its treaty obligations. In other words, His Lordship recognised that 19.1 of the pleading does not take you outside of a need to consider the rights under the treaty. And in our submission, that is entirely right. And packaging things up as, for instance, not being bona fide, all that is doing is referring to, I think you saw the Friendship Treaty, which has a term to act in good faith, and indeed Article 26 of the Vienna Convention on the Law of Treaties, which is in Authorities 19, tab 191, provides that every treaty has to be performed in good faith. So all of these allegations in our submissions are ones which are, in fact, for breach of the treaties. And indeed, Mr. Lord Justice Ricks said in the UKOS case, which I won't ask you to turn up, but is in volume 19 at tab 176, MS 7365 at paragraph 66, that the paradigm principle of non-justability prevents the adjudication on the validity, legality, lawfulness, acceptability, or motives of state actors. And you can test this by looking at 18.1, which is the allegation related to the confectionery on the basis that it was unsafe. That would require one to consider whether the trade treaty that's referred to allowed Russia to block importation of unsafe products, whether in fact the products were unsafe, and whether that gave rise to any rights in Russia or not. So everything comes back to the treaty. The court referred to 18.5 and 18.7 yesterday, but we didn't hear anything from Mr. Thankey to suggest that this was intended to be and was anything other than relied on or the unlawfulness that was relied on was what is set out in paragraph 19. So in our submission, once you recognise that there is nothing left in this if you took out the allegations of breaches of the treaty and breaches of customary international law. Now, we also had some forensic hyperbole where Mr. Thankey referred to things like a threat to annihilate Ukraine. Now, leaving aside the forensic hyperbole, that's actually not part of the pleading, but more importantly, the only allegation that's made is that Mr. Glaziev said things which are interpreted, and that's actually what's important, it's interpreted as being threats to breach the customary international law prohibition on use of force. So nothing else. So there is no pleading, for instance, going back to my Lord Reed's point, there's no pleading that actually this was a case about duress of persons or anything of that sort, or duress of goods. And it's clear that the case is limited. And it's clear in our submission that where you refer to, in any event, a threat by a state, for instance, to go to war, the fact that going to war might cause injuries on both sides, that of itself does not mean that the threat can be treated as one of a threat to persons. And that comes out very clearly from the passages I referred you to in Gentle, and also from Lord Sumption in Belhage at paragraph 234. Now, the final points I wanted to make, first by reference to the Kuwait case, and one's got to always come back to what are the issues which we're concerned with. As you know, Kuwait and Oppenheimer were concerned with a very specific question, which is applying laws of comity. Does one recognize a particular foreign law? So in Oppenheimer, do we recognize the Nazi laws stripping Jewish citizens of their citizenship and of their property? Well, one actually only has to ask the question to realize that the answer is, after the Second World War, obviously no. Not least Germany itself had recognized these laws were improper. In the case of Kuwait, what one was asking, do we recognize Iraq's sovereignty in its own jurisdiction to pass a law which has been condemned by the whole of the international community and including the Security Council? Now, our case is not about comity. Our case is about what are the principles of English law and what, in relation to the law of duress, do we recognize, or what threats can we take cognizance of? Now, I would accept the point that Mr. Thankey makes, that, or implicitly makes, what if you had a similar situation where a state, let's say Iraq, had made threats to do something which had been condemned by the international community, including by Security Council resolutions? What then? Now, in our submission, that doesn't actually affect the law of duress, the English law of duress. What it would probably result in that situation where you had an English law contract, is the English court refusing to give effect to the contract. And the reason for that would be that the English court, the United Kingdom, is obliged under the UN Charter, as it was in Kuwait, to give effect to the resolutions, and it would be inconsistent with the resolutions to allow enforcement of a contract which the UN Security Council had said had been obtained by improper use of force. But in that situation, the English court isn't adjudicating on anything, and that was one of the points that's made in Kuwait. So one needs to, in a way, one doesn't need to answer that question because it hasn't arisen here. Mr. Thankey has been at pains to say, well, various people have criticized the Russian Federation. But the simple point is, I mean, one has to recognize that the dispute that has taken place between Russia and Crimea is to some extent, Russia and Ukraine, is to some extent an East-West dispute. So it isn't that surprising that the United Kingdom government at the moment has condemned the Russian Federation's conduct, and equally that the Russian Federation has vetoed, as it's entitled to do at the Security Council, and equally China has abstained. And so this is, in my submission, all of this is a classic area where what one has is political issues, which if the court goes down the route that the Court of Appeal have suggested and Mr. Thankey urges on you, this court would be intruding into an area which was completely inappropriate. And indeed, this morning's news and yesterday's news is actually important. I'm sure you will all have seen that there was a summit meeting in Paris, brokered by...
Is this a reply point?
There was a summit meeting in Paris, brokered by President Macron of France and Chancellor Merkel, where talks were held between President Putin of the Russian Federation and President Zelensky. Now the point is, and this is why it is a reply point, these are matters...
And it's a point we're aware of.
Yes, but I'm saying these are matters. It just illustrates, I'm sure we're all aware of it, we saw the news last night. And the point is...
We were slightly hoping they might have resolved this.
Well, Not yet. I gather from the report the talks have some time to go. But the more important point is, let's assume the talks are ongoing and we come to a trial. Is it really right that the English court is going to be expressing views about matters which are matters of high policy between these two states? Now, in my submission, it would be really quite extraordinary. And notwithstanding the former Foreign Secretary's views, Mr. Thankey's submissions essentially are saying, well, it's all a foregone conclusion as to what a trial judge would say. Now, in my submission, the court should not reach that conclusion. And once one recognises that, one has to see that the vista opens up of the trial judge saying, actually, what Her Majesty's government says is wrong, and Russia's conduct was entirely legitimate. My Lord, one final point before I sit down is on the question of stay. In a way, the submissions on stay from Mr. Thankey were rather revealing in the sense that one has to remember that the effect of a stay is, realistically, that Ukraine wins the case because Russia is then being kept out. Now, I stood up to say this doesn't arise, and in my submission it doesn't arise for this reason. We say, our submission is, that Ukraine's allegations are irrelevant. They don't give rise to a defence as a matter of English law. So if we're right, there's no room for a stay. Now, Ukraine says, no, we don't have to prove relevance in the way you say, but we're entitled to plead these points, and the points that we run we should be permitted to run them because they fall within the public policy exception. Now, we say that that is all the wrong analysis, but that's the conclusion that the Court of Appeal reached, which is that if the matters are relevant, they can be litigated before an English court. Now, we're not seeking to go behind that. We seek to attack the anterior point and say these issues are not relevant. And so, in our submission, a question of a stay doesn't arise. But if the court came to the conclusion or came to the view that a stay might otherwise be appropriate, in our submission, firstly, it certainly doesn't follow that all issues in these proceedings would be stayed. There are a number of issues which have nothing whatsoever to do with the allegation of duress. But secondly, in relation to the duress case, the court would have to consider what is the appropriate and fair way of dealing with things. In our submission, the only elements that would require to be stayed would be those which the court considered were ones that it wasn't prepared to have tried in this jurisdiction. In our submission, it would then, at that stage, the parties and the court would need to consider whether those issues could be carved out in order to allow matters to go forward. Certainly on the trustees' point of view, and the Russian Federation, the note holder sitting behind the trustee, we do not seek to have any issues stayed. We maintain the position that we're entitled to summary judgment, but if not, then the trustee will deal with these issues in the normal way. So, my Lord, those are my submissions in reply.
Thank you very much, Mr. Howard. Well, that completes the submissions on Chapter 1.
Yes.
And tomorrow we begin Chapter 2.
And Mr. Thankey goes first on that.
Yes. Very well. We'll resume at 10:30 tomorrow.